Okay. Right. Hello, my name is Stephen Scoltetti, and I'm a member of the faculty at the University of Mississippi, and I'm also the director of the Declaration of Independence Center for the Study of American Freedom. Freedom can mean many things. Perhaps the most familiar meaning is that an individual is free when he or she is not being interfered with. But there are other meanings, one of which is that a community is free when the power being exercised upon its members is not arbitrary or capricious. Now, there are many ways to try and organize communities in this free way. And one of the most familiar is to have its members living under a constitution, a set of stable and predictable laws that serve as fundamental rules about how power is organized. The mission of the Declaration Center is to ensure that University of Mississippi students and faculty have an opportunity to explore the nature of freedom and the nature of liberty in America. And so I'm very happy to have organized this Constitution Day event, a day that's meant to inspire reflection, investigation, and inquiry into the US Constitution. Because so many recent Supreme Court decisions raise fundamental constitutional issues, I've invited two distinguished professors of law to lead today's discussion. Stephen Sachs is the Antonin Scalia Professor of Law at Harvard Law School and is a scholar of the law and theory of constitutional interpretation, jurisdiction of state and federal courts, the history of procedure and private law, and the role of the general common law in the US legal system. My colleague, Christopher Green, is the Jamie L. Whitten Chair in Law and Government at the University of Mississippi School of Law. His research has focused on a wide variety of topics in 14th Amendment history, and his research has explored different ways in which key philosophical distinctions inform constitutional theory and interpretation. Steve and Chris, welcome. Thank you both so much for participating. Chris, at this point, I'm going to turn things over to you. Members of the audience, if you have questions you'd like Steve and Chris to address, simply type them into the chat. And with that, Chris, go ahead and take it away.
Great. So I thought we thought it would be most fun to just sort of have a very kind of informal conversation about these, at least one, maybe more, depending on how much time we end up having, cases from last spring. And of course, the biggest one, Dobbs, on abortion, overruling Roe v. Wade, and Casey versus Planned Parenthood. So, Steve, what'd you think of Dobbs?
Thank you. Thank you for having me also. I thought Dobbs was pretty good. It was a very workmanlike opinion. It set out the test and marched through it, presented the evidence. It largely resembled the leaked version, which had the similar qualities of, not trying to be fancy, but essentially setting out what it saw as the legal test and then applying it to the facts in the case. You'll remember that Dobbs is about an unenumerated right, or alleged unenumerated right. And so the first question the court addressed was, well, what is the standard for recognizing unenumerated rights under the 14th Amendment? And existing case law suggests that that is a test that requires a right to be deeply rooted in the nation's history and tradition. It went through the evidence and it didn't find that it was. It marched through the stare decisis factors, as those have been applied in past cases to respect past precedents, and found that they were not fulfilled, and that Casey and Roe did not have to be retained as a matter of stare decisis if they weren't correct as, on the test that one would normally apply. So I would think that, Dobbs effectively was a base hit in terms of the court's conduct of constitutional interpretation. The reason that I say it that way and not in more sort of expansive terms is that I think that, unfortunately, Dobbs didn't do quite enough to lay out the theory that would explain why it's making the moves that it's making. Now, of course, I would say that as a professor, one always wants more theory. But I think part of what might have helped it in the public sphere would be to provide a little more sense, not just that these are the factors that we typically march through, which lawyers know, but members of the public might not, but why these are the factors, what the alternatives are, and why it's pursuing this particular path.
Yeah, and I mean, that's, so you expressed it a little more civilly maybe than I would, but yeah, I almost always I'm looking at these substantive due process cases, and when I explain this to students, I'm always saying, well, this is the answer that they're giving, but what's the question? Why are we looking at this? So why is abortion not protected? They say, well, because of tradition. But then why is tradition supposed to be the rule? And I thought, so when I saw the draft, so what finally came out, very, very similar to the league draft, I was surprised that it wasn't developed more. In part, I mean, I guess, so there were certain parts that I looked at in the draft, and there's all this discussion on Twitter, and I said, I mean, footnote 22, which talks about the privileges or immunities clause, which I and a bunch of folks, 14th Amendment folks, have been complaining the court doesn't take seriously enough. I looked at it and well, pretty short footnote, but surely this will get bigger in response to the dissent invoking these arguments, but it didn't. It was still footnote 22. That's one thing I thought. Now, surely there's going to be more footnotes. I'm not going to just find exactly the same place. But no, it was exactly the same footnote. I think it might have been textually exactly the same. So I mean, your point that well, I'm a professor, of course I want more explanation. That's a useful way to think about it. But I really do think they should explain themselves more, because there are these moments where the court really acts like it's going back to first principles.
Right.
So the very beginning. So you have this question. I mean, there's a number of people who fussed over this question. Is this an originalist opinion? And I would say, well, it's a traditionalist opinion, and that's not quite the same thing. They're consistent. They could be consistent if the original meaning is traditional liberties. So in that sense, it didn't really do the work of original meaning very much, except for footnote 22, which was very, very, very short. But the beginning of the opinion, so both Dobbs and the New York Rifle case have this little ditty at the beginning, kind of asserting the principle, asserting the general idea of original meaning. So constitutional analysis must begin with the language of the instrument, citing a case from 200 years ago, Gibbons, which offers a fixed standard, quoting Joseph Story, for ascertaining what our founding document means. I'm like, okay, great. We're talking about the text. It's fixed. I got to talk about original meaning. No, we're not going to talk about that. So in 1868, we got these words that get added to the text of the Constitution, but we only get a little tiny bit of a discussion of what the words expressed in 1868. 1868 shows up as very, very important in the opinion, but at one point, Justice Alito's opinion says the most important historical fact in whether abortion is protected by the Constitution is the pattern of state regulation of abortion in 1868. And I don't think that's quite how we should do it. You think of forms of originalism. You can ask. You get out of your time machine in 1868. What question are you asking? The first question we're asking when we get out of the 1868 time machine is, what do these words in the 14th Amendment mean? What does it mean to deprive any person of life, liberty, or property without due process of law? What does it mean for a state to make or enforce any law which shall abridge the privileges or immunities of citizens of the United States? And that question, that precise textual question about getting out of the time machine in 1868, only gets a tiny bit in footnote 22. and none at all in the dissent. I was very, very surprised. Did that surprise you?
Yeah, so I think, maybe it was the circumstances of the leak that they didn't want to respond to sort of arguments out in the public because that would be sort of acknowledging that the leak had occurred. Maybe it was that they were hunkering down and not trading a whole lot of drafts after that point. But I was surprised that the majority opinion didn't change more over time. I was also surprised. I didn't think the dissent did the best job. I think that a lot of people who were favorable to the dissent's position on the merits also shared the view that the dissent might not have done the best job. And I think that's unfortunate because it makes for better majority opinions too, when you have a sort of real challenge that puts you to your proof. What I was going to say about the idea of sort of, is Dobbs an originalist opinion? I think it's important to distinguish between two ways that something can be an originalist opinion. One is to say that it is sort of explicitly originalist in sort of character and in appearance. So, you've got lots of James Madison quotes all over the place. That looks kind of originalist. Another way to say it, though, is it originalist compatible? Meaning, could a faithful originalist write this opinion? I don't think that what's going on in Dobbs, other than the footnote on the Privileged Immunities Clause, is distinctively originalist in any real way. In the way that Justice Thomas's concurrence, for example, is distinctively originalist. I think it's quite clear, both here and in the earlier Second Amendment case, McDonald versus Chicago, which held that the Second Amendment is incorporated against the states. It's clear that Alito's heart is in the right place in some sense from an originalist perspective. He clearly is quite respectful of the privileges and immunities arguments, even if the court is not about to adopt them, or it might adopt them, but not yet. But I think what's going on here, which a little bit more stage setting would have helped explain, is something that is, again, not distinctively originalist, but is entirely compatible with originalism. So in my view, if you see originalism as just the proposition that whatever was the law at the time of the founding is still the law unless we've changed it, and those changes have to be done in lawful ways, then it would be perfectly fair to say, hey, we have doctrines of stare decisis. We have this case called Glucksberg that interprets how unenumerated rights are to be found or not found in the 14th Amendment. Neither party is asking us to overrule Glucksberg. So for purposes of the argument, we're stuck with their standard. Their standard says deeply rooted, so now let's do our deeply rooted thing. I think that would have, just that paragraph would, I think, have made it a lot clearer why the court was doing what it's doing, so that it's not saying that we think Glucksberg was definitely right as a matter of original meaning, or this is how we would construe the Constitution if the question were completely up to us. But rather, given what the parties have argued in front of us here, this is what we've got, and these are the applicable arguments.
Yeah, the party presentation bit, I thought they could have made a lot more of, because if you look at, there have been a handful of folks who say, "Oh, I'm an originalist, but I favor the result in Roe v. Wade." So Jack Balkin famously has this article, "Abortion and Original Meaning," where he makes an argument like that. But a number of other people have made an argument like that. It's basically nothing too fancy really about it. It's just I think mostly an anti-discrimination argument. The idea, it seems to be the most common form of it, that distinguishing between the rights of usually privileges or immunities is the way they get to it. But they say, look, pregnant women are citizens of the United States. They get the rights of similarly situated fellow citizens of the United States. Non-pregnant folks have non-pregnant women or non-pregnant or men have certain kinds of rights of bodily integrity. They're similarly situated, the argument would go, because either Judith Thompson is right about bodily integrity arguments trumping any fetal personhood, or because Michael Tooley is right about lack of fetal personhood. So something like that. You could cobble together an argument. I think that's the argument I really wanted the dissent to be making, and I wanted the majority to hit back. But even before the oral argument, I sort of wanted one of the justices to ask ask the abortion clinic, hey, are you making a privileges or immunities clause argument? And if they just say no, well, then you don't have to worry about it. I mean, then you could footnote 22 could be even shorter. Okay. And then, the originalist stuff would be like, okay, should you burn substantive due process down entirely? Or something like that. So I'd be probably dissatisfied about in different ways. But the part of presentation point, I thought they could have said a lot more.
Yeah, I think it would have been helpful to make clear, again, if you're a lawyer who's very familiar with the briefs, and of course they all were, so it's sort of hard for them to remember what their audience doesn't know. But if you're a lawyer who's very familiar with the briefs, then you'll know who's arguing what, and then, it may not be necessary to spell all this out, but for the general public or for other interested folks, it can be very useful to spell all this out and to say, look, we're facing this constitutional question, but we're not doing it on a blank slate. And in particular, we're not doing it unconstrained by what the parties are actually asking us to do. And so that's why we're giving you this answer, but it's an answer very much shaped by the arguments that are in front of us, and not the way Justice Thomas is sort of, going back to first principles and giving a sort of more complete account. And I agree, the dissent, its view of the Constitution is, in my mind, very equivocal. I don't think it really gets down to brass tacks on what it thinks makes a legal argument or a constitutional argument correct. To some extent, it's saying, who cares what the rule was back then, because the people didn't enact the 14th Amendment, men did, and so very sort of hostile to original interpretation. In other ways, it's saying, oh, no, we care about the original rule, that just is different from what they expected it to do at the time, and that's why it has lines like, the framers gave us a Charter of Liberties, et cetera, et cetera. So the Obergefell move of saying, well, the thing they wrote down is very flexible and capacious, and that, which is an originalist argument. It's making a claim about what was the case in 1868. It's vulnerable to historical refutation in certain ways. But it certainly doesn't wear its originalism on its sleeve, let's put it that way. It is very hard to tell where the dissent thinks the moving parts are, and where the dissent thinks arguments for unenumerated rights either succeed or fail. I should say, the majority in responding to the dissent then is sort of equally confused in certain ways. So, the dissent makes the point, hey, if you're restoring Glucksberg to dominance, why not overturn Obergefell? Why not overturn Griswold or Eisenstadt and so on and so forth? And the majority essentially says, like, those aren't the cases before us, which is true, but it would be nice to have an actual explanation of what they think, the right approach would be. Very, very briefly, they say things like, well, the reliance interest might, the stare decisis factors might come out differently there, which is entirely fair for them to say. That's not, but that's the sort of thing you should say in more than 5 words if you're trying to explain why you don't think your result has an obvious consequence for these other cases. Or alternatively, they note a number of times, none of those cases involves a fetal interest, which is also true, but they don't really explain why that matters. I could envision an argument why that matters. If the claim is that there's a right to privacy, then that right looks very different when there is, in some sense, a plaintiff who wants to be left alone by the government, or at least allowed to sort of structure their own affairs by the government, as compared to a situation where the government is automatically balancing the interests of one against the interests of another, which is plausibly what might be going on in an abortion case, where there at least, there might be 2 interests on the table. So it's not hard to come up with explanations for why the majority thought the presence of the fetal interest strongly differentiated abortion from these other cases, but it would have been nice for them to say so.
Yeah. So the dissent, I agree that it's hard to tell quite what they were up to, because I mean, a number of the notes that they strike are really just hostile to 1868. So they have, so there's this phrase that appears, I think 4 or 5 times in the dissent: equal citizenship, which, if you look at the original meaning, folks, I mean, that's all over the recent original meaning of the 14th Amendment stuff. I mean, those are the first two words of my book, for instance, about the Privileges or Immunities Clause. But this one sentence in the dissent was quite jarring. I mean, I think it's in terms of just leaving kind of rhetorical resources on the table, or kind of refusing to engage with this. The men who ratified the 14th Amendment and wrote the state laws of the time did not view women as full and equal citizens. Well, the Citizenship Declaration of the 14th Amendment clearly applies to women. All people born or naturalized in the United States are citizens of the United States and of the state wherein they reside. And in 1866, the Republicans defending the 14th Amendment said over and over again, women are citizens of the United States. They don't get the right to vote. That's why mere citizenship doesn't give the freedmen the right to vote. So women are discussed over and over again in 1868 as getting the rights under the 14th Amendment that are going to the freedmen. So I thought it was, just quite striking that that the dissent used that term, equal citizenship, and specifically said they didn't view them. They didn't, there's no question that people at the time acted inconsistently with their principle of equal citizenship for all persons born in the United States. But that's different from saying they literally didn't view them as full and equal citizens. They didn't act consistently, is how I would put it. Does that sound right to you?
Yeah, it seems like the dissent couldn't decide whether it wanted to say anything from the bad old days is bad and old and we don't need to worry about it. Or, in fact, the tradition of the American people from the founding to today really does support us. You just didn't realize it. Both arguments show up in different ways. And rhetorically, it's more of the former, sort of in terms of content, somewhat more of the latter. But it's very mixed up. And I think that, part of it is writing a joint dissent. Justices Breyer, Sotomayor, and Kagan don't necessarily agree on all points. And so if they had to come up with a consistent constitutional theory, it might not be there. But on the other hand, that's a reason not to write a joint dissent. If you have different reasons for why you think something is true, then you should say so. I kind of wonder whether, Jack Balkin at Yale and others have done books sort of like what Roe v. Wade should have said, what Brown v. Board should have said, what Obergefell should have said. I wonder whether there will be what the Dobbs dissent should have said in future. Because it's, it is useful to have clear interlocutors. It makes arguments better. And I think one general phenomenon that we've seen in American law right now is that, although they're certainly not consistent about it and certainly not, theoretically faithful all the time, I would say it's plausible to say that the right is sort of generally, the conservative legal movement is generally committed to originalism as a method, as a procedure. It is hard to say what the more progressive legal movement is committed to as a sort of general statement of methodology of how to read the Constitution. And in some ways, the absence of that clear interlocutor makes the debate worse because we're not always really clear on what we're debating. It's very easy for folks to talk past one another.
Yeah, I think that's right. Yeah, I just, I always, the first thing I do is when I get opinions to see what's going on, I Control F and I look for the phrases that, I'm, the concepts that I want them to be talking about. And it's really, it's striking that the dissent, talks about equal citizenship so much. I really keep but they don't drive it down back to, so they even at one point talk about a woman as an equal citizen with all the rights, privileges, and obligations that status entails. And I thought, oh my goodness, you're so close to, to really making contact and just engaging with the majority on, a precise textual question. Like, okay, can we have a common question so that we can fight about the answer? Whereas it's so much of the time it just feels like they're just asking different questions. So it has to feel like, is there even a common constitution we know there's got to be a common constitution, but what is the nature of that constitution? It's hard to say what the dissent thinks of it.
Yeah, I mean, in some ways, it also, though, is missing the second half of the equal citizenship argument, which is equal citizenship entails abortion rights. The argument, to the extent that there's argument presented for that, it's very quick, and it does not really join issue with the majority arguing that, which they do sort of under the equal protection heading, that these folks are not similarly situated. There's a relevant difference here. And I don't. It is hard for me to say both. What is the constitutional vision that is implicit in the dissent, and also why do they think that the correct judgment, as they see it, follows from that constitutional position? I mean, it's also a little bit hard to say what the constitutional vision is underlying the majority, but at least it's a little bit more clear, because I think for those who know how to read between the lines, it's clear that what Alito is saying is essentially, yeah, privileges and immunities is probably right, but we're not going to go there right now. So we've got Glucksberg, and let's deal with that until somebody tells us different. Yeah.
The Geduldig section, so just a little bit before the footnote 22 is like, I think, like footnote 17 or something. It went by pretty quick. And I was, when I saw the Geduldig stuff in the draft, I thought, oh, I really wonder what the dissent is going to make of this. They didn't mention it at all.
Yeah.
And one of the reasons that was so striking is that all three of those justices 10 years ago called for Geduldig to be overruled in the Coleman case. It's quite striking in Coleman. The majority didn't mention Geduldig at all. But Justice Ginsburg, she said, "Oh yeah, I mean, it was very clear. She was part of the equal early sex discrimination litigation group, and in 1974, when the court said, yeah, distinguishing based on pregnancy isn't sex discrimination, so it doesn't get whatever scrutiny sex discrimination gets. This is between Reed v. Reed in 71 and Craig versus Bourne in 76. But so in 2012 they say we should overrule this case from 1974. It's awkward maybe for the dissent today, dissent in Dobbs, to say, oh, we absolutely must keep this precedent from 1973, but overrule a precedent from 1974. But you can make the argument in an alternative and say, look, okay, first line argument, you should keep all the precedents, or keep the ones with big reliance interest, that argument. But it's like, okay, let's assume that we're going to reopen all this stuff, reopen the cases from the 70s, as we explained 10 years ago with no response from the majority. We should overrule Geduldig. Okay, I think that would get a response from the majority had they made that argument in Dobbs. But I think they're just cutting themselves off from the strongest kind of initial entree into that argument, and they're willing to use the rhetoric of equal citizenship, but not engaging with the actual doctrinal stuff on that issue. It struck me as kind of doesn't strike me as the strategically best choice. And I'm not kind of from that side, so I'm not it's hard for me to kind of really empathize with, well, why are they making the decisions they're making? But that struck me as not if you point a gun to my head and say, like, give me an argument for abortion rights, I'd give the argument I gave a minute ago, and I'm thinking, well, that's what the dissents would be doing, but that's not. They don't even go, even in the alternative, they don't go that way.
Well, it's really hard to get a good sense of what are the right rhetorical moves in an opinion. As law professors, our job is typically to figure out sort of what's correct and incorrect in an opinion. But for the justices, those are important questions. One criticism that one might levy of the majority opinion is that the main rhetorical error that it had was not opening with a picture. Not saying that, here's a textbook, this is a fetus at 15 weeks. And Mississippi thinks that they want to have a law protecting the fetus, and other people say that violates the Constitution, and then they have the entire rest of the opinion following. But that would clearly make an argument implicitly. Now, maybe they quite sensibly thought that would be a terrible idea because it would make people think that only people who sympathize with the pro-life cause could possibly agree with this opinion. But on the other hand, it's a rhetorical move that could be quite effective, and that the first page of Dobbs is pretty valuable rhetorical space. And so the trying to get a sense of what is the right way to write an opinion like this, and which notes should one sound and which notes should one not sound, is quite complicated. And I don't have any good intuitions about it, which is why I prefer to do academic work than to pretend to be a statesman.
Yeah. And the big cases, I mean, they're thinking like this is going to be excerpted in the case books. This is going to appear on the front page of the New York Times. And there's some question like, do you want it? Are you worried about it being too long? I sort of think, well, just make it longer. Just say the cool, elegant, beautiful stuff you want in the Times, and then put the additional stuff for the nerds, because we want it. Control F. Make it some hits. Get some hits. It can be 20 pages down. But
that's what appendices are for.
Yeah. You have some appendices. So your sense of the stare, do you think the law of stare decisis is moving significantly from Dobbs?
I don't think so. It basically marches through the same stare decisis factors that everybody else would. The only thing that I think there are two things that are clearly different. One is it inters Casey's, settling controversies in the nation kind of stare decisis. That stuff is gone. We're not going to try that anymore. The other thing it does, perhaps, is take a particular view of what counts as a reliance interest. And that's, I think, where the majority and the dissent really join issue on stare decisis. Is this something, what do we mean by reliance? So there's obviously a sense in which lots of people rely on the availability of abortion. They change their conduct based on this feature of the law. What's harder to say is whether folks have relied detrimentally on the availability of abortion. Have they sort of made commitments that now it will create a lot of difficulty trying to unwind? So normally we wouldn't say, for example, that someone who invested in medical marijuana before Raich, that would be a reliance interest that we would really sort of worry about, because it's just a question: is this in the same way that you don't get just compensation if they pass a law banning gambling and you happen to own a casino? So is the sort of reliance that occurred vis-a-vis Roe and Casey the sort that typically gets protection from the courts? And I think that the majority could have done a little bit of a better rhetorical job here, I think, explaining why it is that contract and property interests get special reliance protection. It's not that we love contract and property more than we love bodily autonomy. It's that the idea here is that you structured something in one particular way, and you could have structured it a different way, but you thought that you were doing the legal thing. If we tell you that you need 3 signatures in red ink, and then we tell you next year that actually you needed 5 signatures in blue ink, well, you would have done that if that's what you were told to do. And so we have a special reason not to pull the rug out from under you. Whereas here, I think that it ought to be clear to everyone that the sort of reliance involved in Roe and Casey, even if it might be very important to folks, is not quite the same kind as we're just trying to obey whatever formalities the law gives us and don't replace one set with another when you would have done whatever they asked. Yeah.
My take on the stare decisis is, they're going through basically the same factors as earlier cases have done. I'm always hoping they're going to fix stuff. So I'm always hoping that, don't just give me a list of factors, give me an explanation of how they fit together. So, I've got this view, and it's kind of what Stevens says in his McDonald dissent. He says the original meaning isn't clear enough to dislodge 137 years of precedent. So what does reliance do? It increases the dislodging cost. And what do you need in order to overcome that dislodging cost? It has to be clear enough. So the level of clarity about the wrongness of a decision goes up and up and up as the reliance interests increase. So what I was hoping is that they would not just kind of go through the factors and say, all of the factors support overruling Roe, but to say, here's the big question we're asking about these factors, which is, as the reliance interests increase, is it clear enough? And they sort at one point they respond to the dissent and they say, well, the dissent has the startling view that an egregious error isn't enough. So it seems like the one point where they seem to be saying, oh, so you seem to be saying it is enough.
Which is a startling view, I have to say. Yeah,
to be an egregious error. What does egregiousness mean? I still don't quite know. If egregiousness kind of comes in degrees and means clarity, and the amount of clarity depends on the reliance interest, well, then that's my view. So I'd be happy to interpret it that way, but I don't know if that's a legitimate thing. Looking at Kavanaugh's concurrence, he seems to be saying like the egregiousness of the error is one thing, and then beyond that you have the reliance. So kind of taking the reliance and making it part of the sufficiently egregious thing. It doesn't seem to be his view, unfortunately. But well, I see we're getting a question in the chat. We want to take our crack at this. Using the rationale and outcome in Dobbs, is the right for same-sex couples to marry in jeopardy?
So I would say that it depends in part on what you mean by in jeopardy, but in general, no. So if the question is, do we expect the court within the next decade or two to reverse Obergefell? I would say no, partly because, A, Justice Kavanaugh has already told us he doesn't want to do it, and B, because there isn't a very strong push for the justices to do it. It's not like there is a march on the, for traditional marriage in the same way that there was a March for Life every year. But those are sort of, just causal empirical predictors about the fallible people who happen to be on the court. Doctrinally, does this undermine Obergefell? I would say that Obergefell is certainly weaker post this opinion than it was before, in part because it points out that, hey, Obergefell kind of just sort of hid Glucksberg behind a bush. I mean, it just said, well, we don't really use Glucksberg as much in cases involving intimacy, which is not necessarily obviously true, and also has nothing to do with Glucksberg, and is not, it's sort of, it doesn't go through stare decisis factors, that's for sure. It's just this sort of offhand, brushing away of Glucksberg. And if the court's saying like, no, you got to actually take this seriously, if you take Glucksberg seriously, Obergefell has some trouble. Now, again, it may be that the stare decisis factors work out very differently there. Certainly for folks who are already in existing marriages, it would seem that would be the kind of legal reliance that would, your interest would be at its zenith. I can't remember, there's the great conflict of laws case where Justice Jackson has a dissent saying, if people expect one thing from their legal system, it's to be able to find out whether they are married, and if so, to whom. So, it would be a very big reliance cost to suddenly say, by the way, you aren't married and never were. But, in terms of, was Obergefell correct the day it was decided? I think that the rationale of Dobbs would suggest that it's more iffy.
Yeah, definitely so you've got, Obergefell treating Glucksberg, and it just says, marriage and intimacy cases are a Glucksberg-free zone. And is abortion an, quote unquote, intimacy case? I don't know. Dobbs, the majority, doesn't mention that line from Obergefell.
No, they don't acknowledge its existence.
Yeah, they're just like, we're just going with Glucksberg. And the dissent doesn't really harp on this either. But in terms of like, how do you do substantive due process? If it's in terms of tradition, I mean, no matter what the date, I mean, the tradition as of 2015, it's 34-16 against it in terms of what states have done on their own, even including state courts. So the substantive due process argument for same-sex marriage really doesn't seem like it can survive. It didn't seem like it could survive Glucksberg. And using Glucksberg and treating it like it's the rule it undermines that.
I think that, I'm sorry to interrupt, I think that it is unfortunate that the majority didn't do a little bit more to explain which direction the deeply rooted in history and tradition is supposed to point. You know, a lot of folks have said, why should we care what was deeply rooted in 1868? And I think what the majority really needed to make clear is, no, we're not saying that whatever was deeply rooted in 1868 has to stay that way forever. We're saying that you guys are saying that something was deeply rooted, because that's the only way it can possibly be, you know, protected by the due process clause as against legislative infringement when there's no explicit constitutional right to that effect. And
yes.
So, and that argument, you know, the claim that abortion rights are deeply rooted is pretty terrible. I think that's, I mean, I think the majority is, if anything, it's overkill. It's making the rubble bounce on that argument. I mean, it is very clear that there was nothing like a deeply rooted right in the way that we would normally look for abortion in, you know, any time from the founding to 1973.
Yeah. The little ditty about how recent constitutional arguments for abortion rights were, I mean, on my view of the Privileges or Immunities Clause, I mean, that's all you need is what was the consensus in 1973, not the Roe rule. I mean, you read Roe and you know it's not the rule. You know, it's at least, they list 45 states between Roe v. Wade and Doe v. Bolton that are getting overruled. So, I mean, it almost doesn't even matter how recent it was. Like, even if they'd been making arguments, look, the consensus of the states in 1973, there's New York. There's one state does not make a consensus. So it could have been, you know, much shorter there. But yeah, distinguishing between 1868 tradition as a ceiling and as a floor for 14th Amendment, why does it matter at all? The only way to answer those questions is to dig into the text of the Privileges and Immunities Clause, and you know, they didn't get any pushback forcing them to do that. They didn't decide to do it on their own. The parties weren't pushing them to do that, so we didn't get it.
Yeah, a little bit more clarification would also have been helpful, because a lot of folks have worried that there's a conflict between history and tradition as it's used in Dobbs and history and tradition as it's used in Bruin, which is the Second Amendment, 14th Amendment case that was decided maybe a day or two later.
Or day before, I think, yeah.
Or day before. So there, the court said, the majority says, look, we're not interested in statutes that are too far away from, either 1791 when the Second Amendment is enacted or 1868 when the 14th Amendment is enacted. And nonetheless, here is just, as the dissenting justices note, I was going to say Justice Kagan, because it seems quite clear that she wrote the relevant passages. They do cite stuff going all the way back to the 1300s and so on. So why the discrepancy? And I think that the answer is pretty straightforward, which is that in the Second and 14th Amendment cases, they're actually construing text. They're saying what was the right to keep and bear arms that was being protected at a particular time. What were the privileges and immunities of citizenship? Whereas here, the claim is that there is something that is atextual, that it's not being advanced under a privileges and immunities banner. And the doctrine says, well, we protect it if it sort of over the longue durée of the Anglo-American legal tradition has always been protected. And that, I think that there's a good reason why one would say, okay, for that latter inquiry, we would look starting in the 1300s and going all the way up. But we wouldn't necessarily look at it that way if we're trying to figure out what did the Second Amendment do as of 1791? What meaning was the right carrying there? And again, there are a few sort of droplets of indications there that the majority understands this distinction, but not nearly enough to sort of get it through the public's head, which is not going to read it with nearly the fine-tooth comb that the majority would.
Yeah, yeah. Well, so we should jump over to Bruin in a minute. One thing I did want to add about, is Obergefell about to get overruled? It doesn't seem like there's a challenge. Does seem doctrinally like the basis for the actual Obergefell result, Obergefell opinion, has been largely undermined. You still do have this equality argument that same-sex couples are similarly situated to opposite-sex couples. It depends. One thing that the court's resolution of that is going to depend on is the extent to which tradition informs equality jurisprudence as well as fundamental rights. So I'm very anxiously looking forward to what the court is going to say about the big affirmative action cases getting argued. I think it's getting argued on Halloween. So it's the November sitting, but it starts a little bit before November. And I had last summer, I was thinking, oh, I need to write a new edition of the 14th Amendment volume of our casebook. Now that there are all these big 14th Amendment cases, but we also have a huge 14th Amendment case coming down the pike. So I really should wait after that. But I mean, it is a puzzle. How much does tradition matter in equality cases, as well as substantive due process? You don't quite have the Glucksberg thing in equality land. You have you actually have, I think, it's kind of schizophrenic. You have cases like Heller v. Doe that says the fact that a distinction has been drawn traditionally is good reason to think it's rational. But then you have these heightened scrutiny factors where they say the fact that a group has been discriminated against is a reason to be skeptical when they get discriminated against again, which is that's just to say, when you have a distinction that's been drawn a whole lot in the past in a way that disfavors one group, you want to stop doing it. Stop doing the things that you've always been doing, which is contrary to Heller v. Doe in the 1993, really different from how they do it in do substantive due process stuff under Glucksberg and Dobbs. The religion case, Kennedy, talking about the Establishment Clause. If you think of the Establishment Clause as kind of an equality provision, very much tradition is how they do that. Are they going to look at tradition to decide whether, if they were to revisit Glucksberg, look at tradition to decide whether same-sex couples are similarly situated opposite-sex couples? Are they going to do that in the affirmative action cases? I don't know. If they really took seriously tradition in the affirmative action cases, we've got a pretty strong tradition today of having affirmative action that's quite aggressive. So this is one of the arguments in the quiver of the people defending affirmative action that I really want to see. And just doctrinally, I want to see like what's going to happen in the future for if they do reconsider Glucksberg, but just like other equality, do reconsider Obergefell, but also just other equality cases. What does the historical genealogy of a distinction add to the discussion?
So I think that it's again important to think about the sort of precise circumstances in which the case is going to arise. So just like here, the Geduldig issue is sort of floated but not really engaged with in a serious way. I think that the same is going to be true about most of the pro-affirmative action originalist or original-ish arguments that the respondents in the Harvard and UNC case might make. For full disclosure, my views are not that necessarily of the university, which is my employer. The problem that I see, and this is what was noted in the reply brief, is the same, what I believe it was in Janus, the court called, per Justice Alito, halfway originalism. That we're not going to entertain an originalist argument when you're trying to argue non-originalist things on a very related issue. And, if you're trying to say, like, let's use originalism for this one thing, but please don't use it for that thing over there. In the SFAA cases, it strikes me that the respondents are not asking the court to overturn all of the, all of the federal affirmative action cases. They're not asking the court to overturn all of the, cases that find that affirmative action, or sorry, the cases that find that racial discrimination is equally unconstitutional, regardless of whether it's vis-a-vis the majority or the minority. I mean, there are lots of cases that you could imagine a first principles revisiting of, but that they're not going to ask the court to reconsider. And so once you do that, then it becomes much harder to ask the court to reconsider the application of those cases to this one particular field. And it strikes me that it will be harder for the court to give the same sort of full first principles analysis in those cases. When you think about the, same-sex marriage or Griswold or Eisenstadt, the contraception cases, I think, again, it's going to matter a lot how those cases might come up. So I don't think you're going to see a state try to ban same-sex marriage again and then have the case go up. I think that's very unlikely. And I think if it did, I very much doubt that the court would grant cert, that there would be 4 votes for it. Whereas what I could imagine seeing would be equality arguments being floated in a new context. Let's say a challenge, if the Ninth Circuit holds that there's a right to polyamorous marriage or something like that. And then the court would get involved and say, okay, well, now we've got to sort out all this stuff, and does tradition matter and how? And what sorts of equality claims are we willing to entertain? Where I could see Griswold and Eisenstadt coming up would be something like a state bans a birth control medication that potentially has an abortifacient effect. And someone wants to argue, even if it does, it's also covered under Griswold and therefore has to be secure. And that I could imagine the court saying, I could imagine them batting it away, saying, well, if it's both, then, et cetera. But I could also imagine the court saying, okay, now we have to revisit this part of Griswold. That's the only circumstance that strikes me as plausible in terms of just predicting the future, crystal ball kind of stuff, of when they would look back at some of these decisions.
Yeah, and Griswold, I mean, even if they reconsider it, the fact that so many states allow contraception, I think makes the argument is just much stronger for both for Griswold and for Lawrence. Just under the Glucksberg test, if you're looking at present day consensus, there's a very strong present day consensus for both of those rules. Not the same for the same sex marriage.
Right, though it matters also, at least under Glucksberg, though it may not under various other flavors of different tests. To what extent is this sort of opinio juris? To what extent is it allowed by the states because they think they have to allow it? Chewing gum is legal in every state. We don't think that there's a constitutional right to chew gum. I think that plausibly states think that they have to do this, but most of them think they have to do this because Griswold says so or Lawrence says so, not because they think they have to do this because the Due Process Clause says so. Yeah,
I mean, and probably a lot of them just think, we're just not going to bother banning stuff. I mean, even the Texas
or even
case,
we wouldn't want to because we think it would be unjust,
Yeah, like in the Texas case, they there's a podcast a number of years back about how they were really worried that Lawrence would just that they would somehow allow Texas to just drop the case and not get an occasion to revisit Bowers versus Hardwick. Well, let's talk about the New York Rifle versus Bruin and the what's going on with incorporation these days. So here's the control F that was surprising to me. So this is Justice Thomas writes it. So 12 years ago, he's the one who wanted to use privileges or immunities to incorporate the Second Amendment. Alito, who writes Dobbs, said, no, let's use due process. So Thomas writes this one. You do control F, due process, no hits in the...
Yeah, it's the 14th Amendment.
Yeah, 135 pages of the thing. There's a brief reference to some privileges of citizens talk actually from Dred Scott, which I think is actually, I think it's a pretty strong argument that he gives that, look, in 1857, part of the rationale the court had for saying that even free African Americans couldn't be citizens of the United States was if they were, to be a citizen of the United States means you can carry a gun wherever you go. And that's pretty good understanding of what it meant to be a citizen of the United States. Once we say that they are citizens of the United States and they get the privileges as such, at the time, there was a very, very well understood understanding you can carry guns places. Whether there's a factual development, then it doesn't have. It's not a absolute knockdown argument, but it's very strong argument that could have been made textually really really salient. But I don't blame Thomas so much as he clearly wasn't able to get the court to say, hey, let's at least make an argument in the alternative about how this is working textually.
Yeah, I mean, I would say the one thing about Alito's opinion in McDonald, again, is I don't think it actually throws cold water on privileges and immunities. I mean, Justice Scalia would have. I think he said publicly that he thought that privileges and immunities didn't have much to it. But Alito has not ever taken that view. He's just said we don't need to reach that question. No one's asking us on the other side of McDonald. Chicago isn't asking us to overrule incorporation. So we don't need to worry about whether it's right to do it under due process. We can just sort of keep going with the way we've been going. And then if if later the case comes up, we'll look at it. But he has, various footnotes saying, like, even if privileges and immunities were right, this would still be right. And so, I think, again, it's one of those situations where if one's looking at it carefully, you can get a sense of what's really going on here, which is that he probably thinks privileges and immunities is right, but he doesn't have to do the work of saying so here. But again, it's helpful for the court to clarify and tell people what it's actually doing.
Yeah. So in McDonald. Yeah.
Oh, sorry.
You
want students to be able to understand what they're reading.
Yeah, in McDonald, there's a couple points where they say, Senator Howard said the 14th Amendment would do blah, 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 blah. And 1871, John Bingham said the 14th Amendment. Well, no, they were talking about the Privileges and Immunities Clause. So I've always looked at those as sort of, opening the door to saying, how should we construe the Due Process Clause? To do the meaning that the Privileges and Immunities Clause should have done, because that's what the court did. And if that was a good thing to do, well, it textually doesn't make sense, but it replaces corrects one error with another, and gets us closer back to where we should have been. I would clarify it, but at least they're opening the door to the right kind of evidence.
But so I guess one interesting question to me is, why is there not more buy-in to privileges and immunities across the political aisles? Why is this a sort of conservative coded thing? And I think one answer might be just anything that involves tearing down a whole lot of doctrine looks more conservative than it does progressive at this point. But that doesn't have to be the case. And it's one of those things where, again, it would be more useful to have a clear sort of issues to be joined, where one could say, okay, here's what we think does incorporation in a clear and coherent way, as opposed to, widely varying degrees of commitment to tradition, as opposed to, essentially a natural law view of what rights are fundamental.
Yeah, in the 1980s, Privileges or Immunities Clause was one of the big, John Hart Ely has this big invocation of it. In the 80s, Bernard Segan, was really, using it, saying, hey, this is the way to support things like Roe and Griswold. There's a report from the Reagan Justice Department, I think it's by future Justice Markman from the Michigan Supreme Court, wrong turns on the road to judicial activism, basically saying, here's how we can diffuse the Ninth Amendment and Privileges or Immunities Clause from doing scary judicial activist things. And actually, that report really concedes that, we probably should overrule overrule the slaughterhouse cases. Justice Field's dissent was probably right, that a ban on hostile and discriminating legislation akin to the comedy clause from Article 4 is, that's pretty clearly what the 14th Amendment Privileges and Immunities Clause meant. But it was not like, oh, let's do this. And Markman himself has said, oh, yeah, that's what I said in 87. I still believe it. But I don't think we should resurrect it for the the reasons, the anti-judicial power reasons of the Reagan department in the 1980s. So it is kind of funny that these arguments, aren't getting made on the left. The rhetoric, I mean, and it's a little like the question, why isn't the Dobbs dissent more zippy on this? Because you plug it right in the text. Okay, well, why not make a textualist argument when you've got one? Even in the alternative, you don't have to say we always follow the text, but when we've got a textual argument, heck, we make it. Basically making the rhetorical move. You're paying some of the price. Why not? Get on board the right clause? So,
and I would say that just anything that looks like an originalist reshaping of all of fundamental rights jurisprudence makes folks nervous.
Yeah, I think, but that's what they're getting anyway. So,
yes.
Why don't you come up with rules because the rules, I mean, really the scholarly consensus is, I think getting bigger, that, equal citizenship is a big deal. Kurt Lash, who's been the long time, for a lot of these discussions of the 14th Amendment, we'd frequently say like, oh, well, just about everybody who's written about this recently thinks X, except Kurt Lash. But now even Kurt Lash, with his state citizenship paper from about a month ago, he agrees that citizens of each state get the civil rights of similarly situated fellow citizens. So he thinks there's this big anti-discrimination component there rather than the Equal Protection Clause. Non-citizens, that's one big issue. So Justice Sotomayor, when they start talking about privileges of immunity clause, and I think Timms or something said, well, what about citizens? I've got a way to deal with that. So maybe if they read my stuff on non-citizens, they would be more at ease. So
on the other
it's almost
hand,
no problem that the answer that I can't give an answer, which reading more of my papers wouldn't be the cure. So
no, that's always the cure. But no, I was going to say that it's also just not all that implausible that when they were writing the 14th Amendment, they just weren't worried about government mistreatment of non-citizens to the same extent. What they were worried about was the freedmen, and these were citizens, and that's who they had to protect. And non-citizens they could worry about another day. Some things in the 14th Amendment clearly apply to non-citizens, to all persons subject to their jurisdiction, so on and so forth. But it's not. I find the logical move a little bit strange that one often sees to say, they were bad in various ways, therefore the law they enacted can't have done that. When in fact, the fact that they were bad in various ways might make it more likely that the law they enacted was also bad in precisely the same way. For a sort of less moralized version of it, this came up a lot in the Noel Canning case about recess appointments. They would say things like, well, back then it was really hard to get to the Capitol, so they didn't have any, they wouldn't have thought that you could take an intra-session recess because you couldn't leave the Senate during the middle of the session and go home and come back because that would take months. But of course, one implication of that might be, well, that makes it even more likely that the clause they wrote doesn't deal with intra-session recesses and doesn't acknowledge the possibility of intra-session recesses and is only about inter-session recesses because those are the only ones they were worried about dealing with. Likewise here, it might well be that the clauses that they wrote just don't solve that other problem because that wasn't on their agenda. And we know it wasn't on their agenda because they didn't care as much as we do about it.
Yeah. And in 1870, when they reenact the Civil Rights Act of 1866, they extend it to non-citizens in certain respects and not others. Mm-hmm. But yeah, I've got an argument why it's the Commerce Power that can do that, not 14th Amendment Section 5. Yeah, but I don't know. Don't know if they'll revisit that at some point. But I mean, just the concern about immigration policy and concern about non-citizens' rights, I think that's not going anywhere. So the need to be careful about that kind of thing is certainly coming back. The Halen versus Brackeen Indian rights, the ICWA case, Indian Child Welfare Act case, offers them an additional opportunity to think about those things, but don't know whether they'll take the scholarly route and pick it up.
Yeah, no, and I'm not an expert in federal Indian law, but my sense is that neither are most of the justices on the court, and they don't always, they may not always have the clearest picture of what's going on there.
Yeah, but it is an interesting time. They seem to be willing to upset some apple carts.
Well, I mean, that's what happens when you have 6 votes, essentially, from a particular view of the law. And when the median justice is Justice Kavanaugh, as opposed to Chief Justice Roberts or Justice Kennedy, you have a very different picture of what one might be willing to rethink. I mean, I'm sure if Justice Kagan were the median justice, you would also have a very different picture of what one might be willing to rethink.
Yeah. So I'm always rethink all the things. So, well, we've got. There's 2 more big 14th Amendment huge 14th Amendment cases we haven't touched on very, very briefly. Kennedy, the football coach, praying at the 50-yard line, and then Carson versus Macon on voucher programs, including religious schools. I was thinking about Kennedy when you were mentioning rhetorical strategies and including pictures, because Justice Sotomayor's dissent included some pictures of a bunch of, I think it was a bunch of people from an opposing team joining Coach Kennedy at the 50-yard line. What'd you make of either of the religion cases?
So I don't know enough about the religion clauses or about their incorporation to feel like I can really hazard a clear view here. Partly what's going on in Kennedy is it seems like really just a fight about the record. It's a fight about, when we're trying to construe what's going on here, do we care only about the things that they said that they were basing the later firing on, or do we care about the whole history going up to that point and everything that happened afterwards? And so I think that that's in some ways what the battle of the pictures is about.
Yeah, I was surprised there was so much about that.
Yeah,
because I thought,
well, if folks have an opportunity to criticize their opponents, it's disingenuous, they'll take it. So
yeah, but the kind of the big important thing is this overruling Lemon? Is it declaring it to have been overruled? It's a little odd. They don't. The dissent says the court overrules Lemon, and the majority says we haven't. It's been a bad test for a long time. Do you have any insight?
I don't know why they just couldn't bring themselves to type out the word overruled in that. It seems like that would be an easy move to make at this point. I mean, maybe the thought was we've already been doing so much that we don't want one more court overrules longstanding precedent headline. But I think it's not very helpful of the court not to be very clear and precise in what it's doing. And when they say, oh, we've already abandoned Lemon, the fact is people were surprised by that line. They didn't think we'd already abandoned Lemon. It's just not true as a claim about what everyone would assume the court's going to do next. So, if they want to overrule Lemon, they could do a paragraph or 2 of stare decisis factors and then be done with it. But they could say, look, we have to deal with Lemon in this case. Lemon is clearly wrong, et cetera, we hereby overrule it. Now let's go on. But that's not what they do. And I think it would have been nicer, and I don't think they would have incurred that much cost by doing so, assuming that that's the right, answer to what to do with Lemon. On the Carson case, I have to say, I am puzzled by that case in ways that remind me, and this may not seem immediately analogous, but remind me of things like the Sons of Confederate Veterans license plate case. Because what's going on in those public forum-ish kinds of cases, to my mind, is often about when can the government act as a sort of editor? When can the government select among the kinds of things that it wants to promote? So we know that the government can't tell you not to print something in your magazine. But if the government owns a newsstand on a military base, Does it have to include pornography? Or can it say, look, we're just going, like, a normal owner of a newsstand would have a First Amendment right to decide what they do and don't want on their newsstand. Why does public forum doctrine come in and reshape what the government is allowed to do there? The reason that I find that analogous to the Carson case is because it's asking essentially a similar question. Does the government have a right to give you a ticket good for a secular education anywhere you want? We provide a secular education in our own public schools. We also provide tickets that give you some secular educations elsewhere, and that's what we give out. And do we have to expand it to non-secular educations, which are the things that the plaintiffs want to pursue? To my mind, that's a lot like the newsstand question in certain ways, because we recognize that the government can't generally, punish religion. It can't generally disfavor it. But is disfavoring religion in its own provision of services in this way the sort of thing that it's allowed to do? I find that actually a much harder question than the way that Carson was generally framed, which is, can they exclude religion when you can do anything else, just not religious stuff?
Yeah, that's the when you build the baseline in like that, it's clear how you're going to answer it. But the kind of the bigger, more radical version of, these three cases they've had on kind of requiring religious schools or religious activities to be included in funding. So the Trinity Lutheran and Espinoza and now Carson, they're still pretty far from the big idea, which would be, saying like, getting a ticket that you can use for an education. Well, what is public education itself but giving you a ticket that's only able to be used at one place,
right?
For a secular education that everybody's getting taxed for, everybody with property in the school district is getting taxed for, and you can only use it at that one place. Isn't that enough of a selection that has got to be justified under some's got to be quality provision? So Michael McConnell, years and years and years ago, has this article about the selective funding problem. And he talked about the selective funding just of funding public schools and not private education. So the court in Carson says several times, oh, you've got to, if you don't want to have fund private education, you don't have to. But why exactly does that fit with the way they treat the selectivity? Not clear at all to me.
Yeah, it does seem difficult because it seems like the government has to be able to pick and choose in certain ways. Like, it has to be able to decide, we're going to send a pamphlet to everyone about how to avoid COVID-19. We're not going to send a pamphlet to everyone about the evils of capitalism, even though, the First Amendment generally does not allow the government in the public sphere to favor one message and to dissuade another. And so, we have all these doctrines like government speech and so on to public fora and so on to try and differentiate, well, when is the government just doing its own government thing? And when is it coming into my life and making it hard for me to do my thing? And of course, at some point there's, if the government bought up all the billboards to put up its own messages, it doesn't necessarily, that wouldn't be compelling anyone. It would just sort of be using its market power in a way that would make it harder for other people to get other messages out. We can understand that that's a problem, but it may not be the kind of problem the First Amendment is well suited to fighting against. And I think that, Carson really is one of these baseline cases. When does, do we think of this as allowing private providers of the same sorts of education you'd be getting inside the government schoolhouse? Or do we think of this as, we are banning religious education from this one sort of sphere?
Yeah. Related issues that really didn't get much examination in that Kennedy case. So the fact that he's a public employee, I think it partly might have been just by the way that the school district wrote these initial letters to him saying, hey, don't pray with the, pray at the 50-yard line anymore. We think that violates the Establishment Clause. If they had instead said, hey, after the games, if you could just like kind of go with the students and be with them as they sing the fight song, that would be a better thing to do with your time. So if they had phrased it in terms of restriction on him as an employee, as opposed to, making these really kind of startling claims that end up getting evaluated and found to be false by the court about the Establishment Clause, it seems like they could have made a lot better case that restricting what public employees do is something the state is allowed to do. But that would raise issues like, should we overrule Pickering and Connick? Is the government allowed to just sort of deal with its employees the way it wants? If he wants to pray at the 50-yard line, he can get a different job.
Yeah, I mean, a lot of cases, I think, are in the Establishment Clause and free exercise field are aftershocks of the court having gotten a little too aggressive with Establishment Clause and subsequently backing off. I mean, Carson, too, I think the initial response was, oh, no, we couldn't let you use your voucher for religious education because that would violate the Establishment Clause. And if that rationale no longer works, I mean, this isn't an SEC versus Chenery where they have to have the same rationale that they used to, but certainly it makes it a lot harder for them to argue that what they're doing is okay when it seemed like initially they were basing it on a false constitutional claim.
Well, I see that Steve is back. Have you gotten any private questions that we should answer?
I haven't. I was just going to maybe give you both an opportunity to sort of give a grand sweeping sort of takeaway from this round of Supreme Court decisions. I mean, I know you're both experts at the level of details, but I guess at the level of generalization and big takeaways, how do you think we should just summarize this batch of cases?
I would say it's the year of traditionalism. They're just going back to, they're answering questions with tradition. How do we figure out whether abortion is in the Constitution? Tradition. How do we manage to figure out what gun regulations are? Tradition. How do we figure out what the Establishment Clause means? Tradition. Carson, a little bit different. Okay, West Virginia versus EPA, the big case, not as much tradition. I mean, a little bit more like, the traditionally sized things that the statutes do, major questions doctrines has a little bit of that. But I'm surprised there's not more text, wondering how far this tradition stuff is going to go, especially in the equality realm. But I would say beginning of Fiddler on the Roof, very much, how do we manage the slams the milk crate and shut? Tradition. That I can answer in one word: tradition.
Yeah, I would say that the overarching thread from the past year, certainly tradition is a very significant one. I'd say really it's that the court is now trying to articulate theories. And in some ways, people have said, like, this is a year when the court got super political because it certainly rendered a lot of decisions that had political valence. But in fact, other people who noted this point is not original to me, that, in some ways, what the court's doing is a lot of law. Folks are writing, much more complicated opinions. They're trying to work out their theories and see what implications they have. And now those theories might actually get 5 votes. I think, honestly, one of the most interesting developments of the last year is Justice Thomas's opinion casting doubt on Bowling v. Sharp. And that was not a move anyone would have made beforehand. But now one can say, oh, well, what do you think about this Thomas concurrence? What's the right answer here? And I think that in some ways, when you have both pressure on the justices to explain their results in a theoretically coherent way, there's some amount of agreement, not perfect agreement, it's not always done in a perfect way, but sort of there's some amount of pressure. Explain yourself in a theoretically coherent way. And you've got the votes where some of those things are going to actually get majorities. And it's not just sort of rogue dissents here and there. That what the court is doing is really putting its stamp on the existing doctrine, looking at it all through the lens of its own theoretical commitments. And that isn't always what courts do. I mean, we've seen big shifts in the court before, from, Berger to Rehnquist to Roberts, but in most other cases, most of those other shifts, it really was not, they have a coherent theory and we're now going to see how they apply it in a bunch of different situations, but rather the court has gotten more conservative or more liberal. And I think what makes the sort of feeling of radicalism that folks are sort of who are worried about this attribute to the current court, I think is precisely because, like, oh my gosh, they've got an ideology that they might be consistent about. There might actually be something that would require them to do things differently because they're trying to make intellectually coherent arguments. Obviously that's not to sort of suggest that justices in the past never were trying to make coherent arguments, but I do think that there is something about that makes the current court seem more extreme than it really is. Because if they were really just, political hacks, you wouldn't have people writing concurrences trying to figure out whether they need to be looking at 1791 or 1868. That would just not be the sort of thing anyone would waste their time on if they were just trying to be political hacks. So there's clearly a lot more going on there. They clearly think there's some real law out there. And, we're now seeing how that plays out.
Well, I definitely agree with you about United States versus Madero being the high point. So this is, I was, cited in a dissent 12 years ago, but then, oh my goodness, I actually cited in somebody favoring the result in the majority in Madero. And so April 21st, 2022, it was the Queen's 96th birthday. And it was the 156th birthday of the 156th anniversary of the proposal of the 14th Amendment language on a Saturday meeting of the Joint Committee on Reconstruction in 1866. And when I discovered that, I thought, oh my goodness, the Queen was born only 60 years to the day after the 14th Amendment was proposed, and just striking to think, oh my goodness, she was alive for the vast majority, not maybe vast majority, but a big chunk of the 14th Amendment's own history, which makes the 1868 just feel a lot closer. That sort of coincidence brought that to mind. So
I mean, really, it's only 2 lifetimes.
Yeah,
for that guy who's the grandchild of John Tyler.
Yeah, one of the grandsons died, and I think, but I think the other one's still alive.
Yeah, so I mean, I suppose his father would have been alive on that day.
Yeah,
it's not that far away.
Hard to believe. So, anything about the next Declaration Center event that we need to advertise?
I was just going to say, well, first, before that, thanks, Chris and Steve, so much for doing this. It was really informative. I am excited to announce that Senator Tim Scott has accepted an invitation to come to the University of Mississippi. And on October 14th, he and I will be sitting down to talk about the future of freedom in America. And so you'll all be welcome to join that. If you're interested in future events, also, please go to our website at www.independence.olemiss.edu. And if you'd like to be on our listserv, you can always email us at freedom@olemiss.edu. And so with that, I'll wrap it up and say thank you again, and good night to both of you.
Next opportunity.